Hey there, welcome back to yet another episode in the journey of demystifying the Patent Act. Before starting the session, let me ask you a question. What is the novelty requirement of an invention? I know, pretty late to ask this question at this stage of our journey, but then let's answer this together. An invention is considered to be novel when it is not anticipated by prior publication, prior use, or prior public knowledge. Basically, it should not have become part of the public domain. This is where the definition of absolute novelty come into picture. Now, does it mean any and every kind of prior art will be used against me? Fortunately, no. The Act has defined a few scenarios, use cases, circumstances within which, if you were to have a publication or public display or public working, then it will not be considered as anticipatory against your invention. In this video, we will go over such circumstances and scenarios as defined by the Act one by one. Let's get started with one such scenario which is defined by section 29 related to prior publication. This section defines few publications which will not be considered as anticipatory against your invention. One such publication being of an Indian patent application which was filed before 1st January 1912. Another scenario which has been disclosed is when an inventor's idea or invention gets published before the priority date of their patent application. Under such cases, such a publication will not be considered as anticipatory if the applicant or the inventor is able to prove that the invention was obtained from them and was published without their consent. So they have not published it, somebody else has published it, and they have not taken approval from the true and first inventor or the applicant. And as soon as the applicant got to know about the publication in India or outside, they immediately filed the application as soon as possible. Now, this will not be applicable when the invention was commercially used in India, definitely not for reasonable trials, before the priority date of the invention. In the similar line of thoughts, if somebody else were to file an application in contravention to the rights of the applicant, so the other person obtained the invention from them and filed the application. In such cases also, the filing of such prior application will not be considered as anticipatory. Now, after filing the application, there could have been public display or publication or use of the invention. All such subsequent events also will not be considered as anticipatory because the invention was obtained from the inventors, publication happened without their consent, and patent application was filed in contravention to their rights. So such a scenario should be kept in mind while countering any publication of your own invention. Let's move on to the next use case. Section 30 talks about government communication. Here also it says that any communication with government or communication with a person authorized for the government for the purpose of investigating the invention or the merit of it. Such communications will not be considered as anticipatory. Moving on to the next use case, which is of public display, section 31. Display of the invention with the consent of true and first inventor in an exhibition which is notified by the central government will not be considered as anticipatory. Similarly, use of the invention in the exhibition for the purpose of exhibition will not be considered as an anticipatory activity. Now, once the invention is displayed in the exhibition, there is all sorts of possibility that some sort of publication will come out about the invention. Some sort of reporting, some sort of description will come out of its exhibition. So such publications also will not be considered as anticipatory. Now, use of the invention after its display, use in the exhibition without the consent of the true and first inventor. So now this use is happening after the exhibition is over. Such use will not be considered as anticipatory. We talked about exhibition. There could be a case where the inventor or a person authorized by the inventor would read a paper in a conference in front of a learned society. So such reading of paper will also not be considered as anticipatory. Now, it might happen that post the conference, in the normal transactional activities of the conferences, a publication might come out. So that publication also will not be considered as anticipatory, provided that an application for the invention is filed within 1 year from the starting of the exhibition. So there is a grace period of 12 months that is provided to us for all these activities not to be considered as anticipatory. Moving on to public working, section 32. So the public working of the invention by the true and first inventor or any person authorized by the true and first inventor will not be considered as anticipatory, provided such working was strictly for the purpose of reasonable trials and there were reasonable requirements for the trials to be conducted in public and not in closed doors. Here also, provided that a patent application is filed within 1 year from the date of public working for it not to be considered as a prior art against your own invention. Finally, the concept of priority date under section 33. Controller shall not refuse the grant of a patent or patent will not be revoked or invalidated by reason only that the invention was used in India or published in India or elsewhere after the filing of provisional application as per section 9(1), 2 and 3. So once you have filed a provisional application, you already have got the invention date. So post this date, any activity with respect to your invention, publication, display, use, will not or cannot be considered as anticipatory. Similarly, this thought can be extended to the conventional application also, because we take priority from conventional application or we take priority from the provisional application filed in the convention country. So before filing application in India, if the invention was used in India or published elsewhere, then it will not, such activity also will not be considered as anticipatory because we are claiming priority from the earliest provisional date. That's why filing provisional is an important aspect to secure earliest priority date and having the freedom to do what we want to do with our invention. Finally, so all the circumstances as enumerated under section 29 to 33 will not be considered as anticipatory when evaluating an invention. So this brings us to the end of this session. In the next session, we will discuss about the provisions of the grant of the patents, the rights conferred to the applicants, and the conditions under which a patent is granted. So I'll see you in the next session. Till then, take care and be good.